And if you know people who wanted to see this and didn't get a chance, I will be posting a link to this recording as well as some of the materials I'm going to be using. And so it's really great to see so many of your names, people I've known for a long time. I have to admit, I'm a little nervous because I haven't done this in a while. So I hope it's like riding a bike and I never forget. So the best thing to do is for everyone to make sure that your own feed is muted. We don't get feedback.
My
And
cousin doing a thing on the Supreme
begin.
Court.
What's happening?
Just this past stuff.
Okay, I'm muted.
Why isn't the audio coming through the TV?
Whatever you want. I don't care. I want to hear
Okay.
Yes.
Well,
That's your cousin. Not the place to do it.
most of you know me, but my name is John DePippa. I'm the Dean and Professor Emeritus at the William H. Bowen School of Law at the University of Arkansas at Little Rock. Now, it should go without saying, although I have to say it, that whatever I say will be my own opinions and do not reflect those of my former employer, the Bowen Law School, or the University of Arkansas at Little Rock, or the University of Arkansas system, or anybody else in state government. It's all me.
John, can you speak up, please?
So here's what I want to do. Since we have a wide range of people, some with law backgrounds, some not, I'm going to spend a couple minutes just explaining some basic Supreme Court stuff. I then want to do a review of the last term, focusing on the most important cases. But I'll be honest, there are a lot of cases, a lot of very important cases. So I'll try to get the most important. And we'll take some questions at the end through the chat. Now, I'm not going to be able to monitor the chat during this broadcast. So at the end, I'll look it up and then take your questions, okay? So, Supreme Court has two primary functions: to interpret federal statutes and to police constitutional boundaries. They have one term per year, starts the first Monday in October, usually finishes by the end of June, unless, like this year, something really odd happens and you had them running over to July 1st with the Trump case. Usually, though, that last week is packed full of what's very often the most important cases. Now, all appeals to the court are discretionary. That is to say, the court doesn't have to hear any of these cases. They come from state courts only if there's a federal issue, or one of 11 federal courts of appeals. It takes 4 justices to agree to hear a case in the ordinary course of business. That's called granting certiorari. There are some unusual situations where it takes 5, but that's truly unusual. So 4 justices get these petitions and decide to take a case, the whole court hears it. Now, the court only hears about 1%. It's now less than 1% of the cases that they are requested to hear. This year, that translated to granting cert in 61 cases and then issuing decisions in 59 of them. Now, it used to be that they decided twice that number. When I started teaching in the 80s, it was an ordinary course would be 120 to 130 cases. So their workload in many instances is going down. Now, if you're interested, there's some good places to get general information. The Legal Information Institute at Cornell has a good site for the opinions themselves. You can also get them from the Supreme Court website.
Did you change this again?
But another great resource for all things Supreme Court is called SCOTUS blog. And there you can get links to all of the opinions
I
as
was like,
well
why
as
did it
all the
stop?
filings in each case.
I don't know how to
You
do
can
the
get
cat, but I
blog
got it.
posts, history, mini
Maybe if-
symposia. And then when the court announces opinions, they'll do a live blog, which is where I go, because usually their information is up before it even shows up on the Supreme Court website.
Well.
So those are two really good places. Now, if you're interested in stuff about tonight, the recording will be posted on my YouTube channel, and I'll send this stuff out on Facebook as well. I also have the PowerPoints that will be posted to a shareable link on Google Drive, and I'll also have them on my not frequently used, but maybe soon to be blog. Okay, so let's jump right into it. Here are what I think are the major observations, at least in my opinion. This term amounted to a tremendous grab of power by the United States Supreme Court. When all is said and done, the only branch of government that got more power than the president is the Supreme Court. And even then, in the final analysis, it's the Supreme Court who will be able to say which acts of the president are entitled to immunity and which acts are not. The Supreme Court hobbled the administrative state. Now, they've been doing that for several years. This is part of a long-term project by conservative legal thinkers, and it reached a crescendo in 4 cases this spring. There's something weird going on in the court with originalism. That's the philosophy that the Constitution should be interpreted consistent with what the people thought it meant at the time it was written. Okay? And either they've cut back on what was the most extreme version of originalism in the gun decision 2 years ago, or maybe they never were that committed, or they're rethinking how it works. So there are going to be some interesting things about originalism. The court has continued to hobble public corruption prosecutions. They did that in 2 ways that I'll try to highlight. And then for me and some other court watchers, the rise of the Justice Jackson and Justice Barrett dimension is an interesting thing going on in the court. If you ask me, the 2 most interesting thinkers and writers on the court right now are Justices Jackson and Barrett. And you don't have to agree with them, but you do have to admit that what they say and what they write really makes not just a lot of sense, makes you think really hard about the positions they're taking and that you're taking, and can be very persuasive. Corollary to that, you saw to some extent Justice Barrett striking out a little bit on her own. We'll see how far that goes in the future. All right, so big decisions. Obviously, the Trump case. We've got the Trump cases, 3 of them, 2 of them directly involved the former president, 1 indirectly did. We're all familiar with Trump versus US. We tend to forget that in February and early March, the court decided Trump versus Anderson. That was the 13th Amendment or 14th Amendment, Section 3 case. And indirectly, the court decided this case involving what evidence can be used to prove obstruction of a official proceeding. That's one of the charges in the Trump case. So let's start with the big one, Trump versus United States. On the screen, you'll see the holding. That's the official holding. I also took it from SCOTUS blog, and so some of the links are embedded there. But it said essentially that the president is entitled to some form of immunity for some of the president's actions, but no immunity for unofficial actions. And the court divided the
Joe doesn't have
immunity
muted. Keeps coming up.
buckets into three
Just
buckets.
It's not my
The court
problem.
said
No.
the president is entitled to absolute immunity from criminal prosecution for acts within the president's core presidential powers. And they gave some examples of that. Pardons, when the president acts as commander-in-chief, when the president makes some appointments. The Constitution in Article 2 sets out the powers of the president, but they're not very precise. Article 2 says the executive power vests in the president. The president shall take care to faithfully execute the law. The president is the commander-in-chief. And there are a couple other places where the president is given power. Pardon, for example. When a presidential action falls within those core presidential powers, according to the Supreme Court, the president enjoys absolute immunity from criminal prosecution. The other extreme, the president enjoys no immunity for unofficial actions. And then there's a bunch in the middle. Not core presidential powers, not obviously unofficial acts. For those acts that are within the outer perimeter of the president's powers, the president gets presumptive immunity. What does outer perimeter mean? It means any action taken by the president that is not manifestly or palpably beyond the scope of presidential power. Now, whatever the heck that means, that's a really, really wide net. That casts a huge net around most presidential powers. So there's presumptive immunity within that big group of things that aren't core, but are within the outer perimeter. Now, obviously the distinction then between what's presumptively immune and what is an unofficial act and not immune is really going to be important. And the court, a number of times in the case, points out that these are fact-sensitive decisions, and the lower courts must make those determinations before anything in the case proceeds. So before a case can go to trial, before really, as I read the opinion, before any kind of evidentiary motions, the trial court in any of these cases has to decide whether the act is absolute, presumptive, or non-immune. Now, how do you do that? The court said you can't inquire into motive. That is, you can't ask why the president did something as a way to show whether it was unofficial or not. And you can't use presidential records to show if it's unofficial or not. Why not? The court says, well, the whole point of immunity is to make sure a president can vigorously and robustly exercise presidential powers. They believe the framers wanted the president to be this person who could act without fear. And therefore, criminal immunity is necessary because you wouldn't want a president making decisions based on their fear that they're going to be prosecuted in the future. Therefore, you can't inquire into president's motives or use the presidential records, because that would be just another way of allowing the president to worry about being prosecuted. Second thing they said is, you can't say something is an unofficial act just because it violates some general criminal law. So think about that for a moment. Even if a president acts to violate the law, say some general statute, and I'll give you an example in a second, that doesn't make it an unofficial act. The court said as long as the president is objectively exercising some power, either from the Constitution or given to the president by Congress, that's enough. Now, in this presumptive category, the court said, well, you can prosecute these acts. In other words, you can overcome the presumption of immunity if the prosecution will present no danger of intrusion on authority and functions of the executive branch. And let that one sink in. Even if you can show that there's some reason to prosecute these, you can't do it if there's any intrusion on the presidential authority and functions. And the dissent points out that that practically makes every action of the president absolutely immune, as long as the president is acting under some cover of official power. And then finally, there's no immunity for unofficial acts. But I'm not sure I know what's left with this. So the court gave us some examples. They said in the actual indictments in front of them, there is absolute immunity for any conversations the former president had with the acting attorney general, or any conversations he had when he threatened to fire the other acting attorney general. Court said president has core power to supervise the executive branch, to hire and fire close aides, members of the cabinet, etc. And you can't interfere with that, even if what the president was asking for was a sham or a violation of some other law. And so there's a large part of the indictment that lays out the conversations the president had with the attorney general, where he asked him to send a letter claiming that there were violations of the massive election fraud in Georgia and other states. None of that was true. That would have been a sham investigation. And the acting attorney general was going to send it to the states saying, hey, you ought not to certify these electors. That can't be used anymore going forward in this Trump case. It's absolutely immune. So future presidents then can immunize themselves simply by asking one of their aides to do an illegal act for them. In this context, the court also said that the president has the authority to faithfully execute the law, and therefore, when the president was inquiring about election fraud, the president was attempting to faithfully execute federal election law. Then they said, you know, there's a second category, a whole bunch of conversations with Vice President Trump. And there they said that's in that presumptive category because presidents and vice presidents have to stay in touch. Vice president has a number of constitutional duties. The vice president might take over for the president. And so some of those conversations could be immune. So they sent that back to the lower court to figure out whether any of those were. But when you read the opinion, at least in my opinion, it seems like they put their thumb on the scale, suggesting that most of those things, those conversations, would be immune. And inquiring into them would interfere with president's function and authority to confer and work with the vice president. And then finally, they said there's another section, not final, there's another section of the opinion of the indictment that laid out conversations with state officials. You know, y'all remember the famous phone call to Georgia asking to find 11,000 votes. There, the court said, well, you know, maybe some are private, maybe not. And we need the lower court to go through and look at every single instance to determine if there was any exercise of presidential power in that regard. Now, if you look across the screen, on either end, you see Mark Meadows and then Ken Chesbrough. Those people were working for the president. And so it seemed to me that in the Trump indictment in federal court, as well as the Trump indictment in Georgia, some of those conversations with people like Meadows and Chesbrough might be absolutely immune. But in any event, each of these courts, the federal court and the Georgia court, are going to have to go through each and every allegation in the indictment to determine if any of those are entitled to immunity. And they have to do that before proceeding with anything else. And you saw that the judge in the Mar-a-Lago case suspended all action in that case and has set up a briefing schedule to determine a briefing schedule. And so if anything comes of this, it certainly will be delayed while the lower courts work through this. And then finally, the indictment uses statements up to and on January 6th to also show the president's violations of the law. And again, the court says, listen, some of these might be protected because presidents have a core function to speak to the country. And they speak to the country about all kinds of things. And so you have to analyze each and every bit of evidence the prosecutor puts forward by looking at the form it took, what it said, its content, and the context in which it was said to determine if any of those are entitled to immunity. So you might, for example, and this is just an off-the-cuff comparison, on January 6th, the former president sent a tweet and did a video, and the video essentially said to the people in the Capitol, go home, it's okay, things are over. As I read the court's opinion, that might be an official act entitled to immunity. On the other hand, the president was speaking at this rally, and even though he's behind the presidential seal, maybe some of those quotes and comments were more directed to his re-election. In any event, again, the court has to go through each and every one of these cases, instances, to determine if immunity should be granted. Now, some of you are familiar with TV commentator and blogger Asha Rangapapa, and she made a little chart as to how this is all supposed to work. And I think it's really pretty useful. You know, it starts with, is this a core or exclusive Article 2 function or authority? If yes, absolute immunity, case stops. If no, is it within the outer perimeter of executive authority? If no, if it's palpably beyond, no immunity, case proceeds like an ordinary criminal prosecution. If yes, president gets presumptive immunity. Would it intrude on the authority and function of the executive branch? No, case proceeds like an ordinary criminal trial. If yes, can't inquire into motive, can't use conduct of the president, can't use evidence of motive or intent for another crime. This is a pretty small window once you find that there's some form of immunity. So here's what I think. I think the opinion I said this before. The opinion was bad enough the first time I read it. It gets worse every time. And it gets worse every time because each time you read it, you see the gaps. I think Lawrence Tribe called it sophomoric. That's probably a kind description. What it is not, it's not an originalist opinion. It's not an opinion that relies on, at least properly relies on, the Constitution's text and the framers' understanding. The Constitution's text, first of all, says nothing about immunities. And the framers knew how to give immunity because they did give immunity to members of Congress in the speech and debate clause. So it's not like they weren't thinking about it, but the document is silent about criminal immunity for the president. And if anything, the Constitution's text empowers Congress to do something if they wanted to through the necessary and proper clause. So if any part of the text creates some possibility of immunity, it's only through the exercise of congressional power. Also, in the impeachment, called the impeachment judgment clause, the Constitution says that the president nevertheless could be prosecuted after impeachment in the ordinary course of law. And so if there's anything in the text, again, that speaks about this issue, it speaks in a way that is contra to the opinion. And there's at least two prominent framers, Thomas Jefferson and Alexander Hamilton, who clearly did not believe that presidents would get immunity from criminal prosecution. And there are a number of other comments. Now, the court accuses the dissent of cherry picking sources, but that's rich coming from the court that cherry picked sources. So it's clearly not originalist. In fact, the analysis is largely policy driven, not law driven. It's largely about, gosh, what happens if we have, if we don't have immunity, and in the future, people start bringing criminal cases against former presidents, that might make presidents afraid to act. Interestingly, we've never had immunity up to now. Presidents have not seemed to be reluctant to act. And yet the court makes that a central feature of its analysis. That's a policy question. And again, it seems to me if Congress thought that was an issue, they could give immunity by exercising their necessary and proper power. Not a question for courts to decide. Secondly, I don't think the decision is supported by the available precedent. There isn't much. Nixon versus the US, which in the Watergate era said that the president had some ability to protect confidential communications, but not an absolute ability. And in any event, that court was clear that whatever interest the president had were subordinate to the interest in justice in a criminal case and in bringing the guilty to justice and freeing the innocent. And so the Nixon versus US case, even though the court seems to think it's a big deal, really was very heavy on, we think presidents have to obey the law. Nixon versus Fitzgerald, that's where the court granted absolute immunity from civil damages to presidents. And the court cherry picks quotes from that case. But that case was very clear that immunity from civil cases is much different than immunity from criminal cases. Because there'll be more civil cases.
Yeah, he had to zoom
They could
here.
hamstring the president, and that criminal cases aren't going to come by very often. And there are a whole lot of other procedural protections in criminal cases. Rules of evidence, due process protections that would thwart sort of rampant use of the criminal process against former presidents. So they turn those opinions on their head, essentially.
Yeah, okay.
Third, the court, I think, undermines the separation of powers.
Good on Facebook.
Now, they
Yeah,
say
already
that the
said
case
in the
is
video.
grounded in the separation of powers, that they had to make sure that the
But never,
president's
but then, but when
Article
you,
2 powers weren't diluted out of fear that he was going to be criminally prosecuted for his work. Again, we've had over 200 years of presidents. They didn't seem to be fearful men. But if you think about it, the case guts the actual work of the executive branch and of future presidents. If the president's core duty is to take care that the laws be faithfully executed,
Zoom link though.
I
but
found
the
Zoom
court
link.
says, yeah, but there are some things that you can't enforce because they were the ex-president's actions. That undermines the president's ability to, in essence, faithfully execute the law. And for fear of how to fear
I do, I know, that's
future
how I finally got this,
problems,
finally found it.
here the court guts the actual work of the current executive branch. Fourth, you read the case, the court seems to accept the Trump's tendentious phrasing. Remember, the former president has frequently said, presidents need immunity because, gosh, if we didn't, we wouldn't be able to do anything. And then the court, throughout its opinion, says, you know, we have to make sure that in the future, we don't get these rogue prosecutors bringing cases against presidents or a president in the future going after their political rivals. Well, doesn't that seem to implicitly accept that the current case is political? Because courts are supposed to decide the case in front of them, not some future case. In fact, those justices said that sometimes. And yet, if you read the opinion, it seems to say, yeah, you know, this is really troublesome and we think maybe there's some problems. And it assumes, if you will, that future presidents are going to act in bad faith. It's an odd sort of framing, considering that presidents for over 200 years have never acted in this kind of bad faith. And that this is the only instance where a former president has ever been prosecuted, but it's also the only instance where a former president tried to do what this president did. So it's a weird way to accept the framing of the case. They also did that in the 14th Amendment case. And then I mentioned this, there's a lot of policy, not law. The court broadened the question. Originally, the Trump appeal was only about absolute or categorical immunity. They broadened it to include this case for the ages. They gave unnecessary advice, as even Justice Barrett pointed out, about what evidence can be used and what process. And they got the policy concerns backwards, or if you will, upside down. Because maybe the policy concern should be that if a president has this broad, enormous power, maybe that's what we ought to worry about. We ought to worry about the president exercising these powers corruptly. That's the real concern going forward, not a concern that a president might on the margins in some private way do something wrong. The real constitutional question seems to be that presidents ought not to corruptly exercise their power. And yet, when presidents exercise their constitutional powers, the court gives them absolute immunity. That just seems to have it backwards. And lest we forget, two other cases have an effect on this. Actually, before we do that, let me go back. Here's what you're seeing now. Because this ruling is so broad and it purports to give guidance, but gives very little actually, each of the current cases against the former president will be delayed in some way. So for example, the state case where the former president was convicted of those 34 counts of fraud in New York. Sentencing was supposed to happen July 11th. That's been put off to September because some of the evidence against the former president came from aides and conversations he had with them, like Hope Hicks. And so the former president's lawyer said, you have to throw the conviction out because it wasn't based on proper evidence. I've already said the Mar-a-Lago case has been put off to consider this issue. There, the former president's going to argue, listen, when I took those documents in the first instance, I was still president and I had the power to take them. And when I did, that was an official act. And you can't introduce any evidence then. And in fact, I'm immune from prosecution for violating any law concerning the acquisition and retention of those documents. When I took them as president, I made them my documents, and I'm immune from prosecution for that reason. That's the official act. Again, this case involved all the Trump indictments relating to January 6th. That's going to be going on. And then at some point or another, the Georgia case will have to have these same considerations. So all of those cases will be put off. None of them are going to happen before the election. So 2 other Trump cases, right? Because the Constitution makes Congress rather than the president, the states, responsible for enforcing Section 3. Only Congress can determine if Section 3 keeps the president off the ballot for being an insurrectionist. Now, that was a unanimous decision. But that's another decision where there's nothing originalist about it. In fact, the overwhelming number of historians and legal historians came out on the other side. But here the court said, well, we worry that one state could keep a president off the ballot, and then other states might retaliate, and therefore we need to make sure that everything is uniform. But again, notice how that accepts the bad faith framing of this, right? That using Section 3 was in somehow bad faith, therefore other states are going to retaliate in bad faith against President Biden. Therefore, no state can enforce Section 3. Only Congress can by enacting specific legislation that applies to the president. That's policy again. And then finally, in a case, Fisher versus United States, that does affect one of the charges against the former president, the court narrowed what could be used to prove that charge. There's a lot of ins and outs, but essentially it said that you have to show that the defendant impaired the availability of some official document and not obstructed in any other way a proceeding. Now, there's still some other charges left, but that's a pretty narrow framing. So I see that some people can still be heard, so make sure everyone is muted. Okay. I'm going to go through these quickly so we have some time for questions. The court reshaped the administrative state. These are big news. 2 cases, Relentless and Loper Bright, overruled something called Chevron deference. Another case extended the statute of limitations virtually an unlimited way. And then another case basically put another hurdle in front of environmental regulations. In the Loper Bright Relentless case, the court said that courts, not agencies, get to determine what federal law means. If Congress writes an ambiguous statute, then an administrative agency issues a regulation. You can file a lawsuit, and the court will decide what the law says, not the administrative agency. Will not defer to their judgment. That was a 40-year-old precedent that the court arrived at unanimously to try to make sense out of a essentially hodgepodge set of rules. So that means it's open season for courts to second guess every regulatory decision going forward. The court said decisions that relied on Chevron in the past are still okay, but going forward, all these new ones are up for grabs. In JARCSI, the court said that if a regulation imposes civil penalties, it has to be done by a jury in a federal trial and not by the administrative agency. It doesn't matter what Congress says. In the Corner Post case, the court said the statute of limitations on a regulation runs as soon as the regulation applies to the person, not when the regulation is issued. It's a 6-year statute of limitations. In this case, the regulations were issued in 2010. Corner Post didn't go into business till 2018, passed the statute of limitations, challenged the whole regulation on its face. The court said, that's okay. So effectively, there isn't a statute of limitations for administrative regulations. Then in the Good Neighbor case, it was a set of rules that were going to require states that created acid rain pollution to impose certain regulatory and environmental restrictions so that they didn't harm their downwind neighbors. The court imposed some new requirements and suggested that in the future, these weren't going to be kindly looked at. This was a case where Justice Barrett broke with the conservative majority. In 2 cases, the court sidestepped important abortion decisions, and in fact, should never have taken those cases in the first place. In the Alliance for Hippocratic Medicine, the court said that the challengers, an anti-abortion group and some doctors who belonged to it, challenged the regulation concerning mifepristone. There, the court said, listen, you don't have any injury. The plaintiff said, we might be called to the emergency room to help out, even though it's never happened before. Or we might have to deal with the after effects and treat somebody who had a bad reaction or a bad outcome from mifepristone. And the court said, if those were ways to get standing, everybody in the country could sue whenever they wanted to. In Moyle versus US, it involved preemption. Montana law, like Arkansas, provides almost no exceptions for abortion. Federal law from 1986 requires emergency rooms to stabilize people who come to them. Montana said that would violate our law. The court took cert, but then said, nah, we made a mistake. There was really no reason to take the mifepristone case. The court could have ruled on standing and ruled on the merits. They didn't. They left the Comstock Act, which would ban the use of mails and make it a criminal violation to use mails to send anything related to an abortion. And there are better plaintiffs available. So this is not a reprieve for pro-choice conditions. This is really just kicking the can down the road. Same thing with this case, the federal preemption case. It was decided as denied improvidently granted. It establishes no precedent. It only applies to Montana, and the case has to go back to the lower court for trial anyway. And when the court heard oral argument on this, there are a number of justices who did not think the federal statute preempted the state law. Real quickly, the only gun case, an individual who was found by a court to pose a credible threat to the safety of another may be temporarily disarmed. Now, here, the court clarified their decision from 2 years ago, where they seemed to require that any regulations on guns had to have some exact historical analogs. And in the Brahimi decision, the court said, well, we don't mean exact, we mean just some sort of principles that are analogous. But then my question is, that's not originalism anymore. That's what the living constitutionalists have been doing for decades. That's precisely what the Casey decision said. And if you look at what the holding is, it's pretty narrow. It only applies to an individual who has a court hearing, who's a credible threat, and temporarily disarmed. So red flag laws would fall within that, but these aren't creating categories for gun regulation. Social media. There are a bunch of those cases. They're somewhat technical, but I think the best way to describe them is social media platforms have First Amendment rights. In the 2 net choice cases, Florida and Texas passed laws that purported to require large social media platforms not to exclude content based on viewpoint. But the Supreme Court said, you know, social media platforms are sort of like newspapers or TV stations, and they decide what content's there. And even if they include most content, they still have the right to choose what not to include. But they sent the cases back because the statutes really were very, very broad, and they had to decide which platforms they actually applied to. But they said both laws are probably unconstitutional. Murphy versus Missouri claimed that the federal government coerced social media platforms into removing misinformation, and that was censorship. The court said, well, whatever that question is, there's no standing here because no one was injured, at least none of these plaintiffs were injured. And the question hinges on what the government official says or does. And you ought to compare that to the National Rifle Association versus a Volo case, also decided this term, where the court said there was a cause of action for the NRA to sue a New York state regulator who urged other entities to terminate their business with the NRA, and that could violate the First Amendment. And so when the government tries to have some control over what social media platforms post, depends on how far they go. And finally, there was a case that involved a government official who blocked a user on, I think it was his Facebook or Twitter account. And there the court said, the Constitution's only going to matter here if this person took state action. And the person takes state action only if that person has government authority and uses it. And they sent that back for a hearing. They also sent back another case that found state action based on the appearance of the various posts. So I put this one up there not because I'm picking on Senator Ervin, but because it shows you some of the questions that courts are going to have to look at. So you see her background picture says she's from the Senate, but then this profile picture is of her and a horse. She has a list to her Senate website, but everything else in her description is all personal. Most of what you find on her Twitter account is personal. after this opinion, when she runs this Twitter profile, she's not engaging in state action, would have the power, like any of us do, to block certain people. So I am going to call that quit. Okay, so Rochelle, you're probably right. It must have been Idaho. It was somewhere up there. So if anyone has any questions, I'd be happy to take them. If you can unmute and ask them, that would be fine, or post them in the chat. No? Yes?
Hello, Dean DePippa. This is Troy Price. I am wondering if some people have posed.
Patty Bell,
If
did any good news come out of that opinion? I guess you mean the Trump versus US opinion? Well, yes. The good news is that it wasn't worse. The good news is that the court didn't accept the former president's initial claim that everything was immune. And that on the surface, those three categories are not unreasonable ways to think about presidential immunity. If you think there is some immunity, those aren't unreasonable ways. I think the bad news is how broadly absolute immunity cuts and how broadly presumptive immunity cuts and how little evidence is available. Now, there was a little fight in the court in footnote 3 where Justice Barrett criticized the majority and said, look, you're going to make even a bribery prosecution almost impossible. And the court said, well, not really, because we can still introduce evidence that somebody got money, and presumably we can introduce evidence of that person who says, oh yeah, I talked to the president and he offered to pardon me if I gave him money. But that's, again, a pretty narrow window. And so on balance, Patty, I'd say not much good news came out of that.
In the extreme example of a president ordering the assassination under its power as commander-in-chief of a political rival, what do you think would be the court's analysis there?
Wait.
Assassination under its power as commander-in-chief of a political rival. What do you think would be the court's analysis there?
Wait. Hold on a second here. Hold on a second here. Okay. It's important not to conflate immunity from criminal prosecution with the ability of the president to do something. So if the president orders the assassination of a political rival, and let's say calls up the chairman of the Joint Chiefs of Staff and says, I'd like you to go kill this guy. That's an exercise of core constitutional function, commander-in-chief. You can't inquire into motive. It's absolutely immune. I don't see any other way around that analysis. Now, presumably the president could be impeached and removed from office, but not prosecuted for that. Now let me think about the bribery example. The easiest bribery example to prosecute a president, to make it unofficial, is if the president at a political fundraiser for his reelection campaign is talking to somebody, and the person says, "I'd like to be ambassador." President says, "Give me $1 million." The person hands it to the president on the spot. No official act has happened yet. Presumably that's private. Even that might be entitled to some presumptive immunity because the president is exercising the power of appointment. Under which category, if a president refused to leave office at the end of the term? It's a really good question. And I think it goes back to why the president's refusing to leave office. Now, again, remember, we're talking about immunity from criminal prosecution, not necessarily removal from office. And so if we take the January 6th example, the president said, I was entitled, former president, entitled to do everything I did because I was trying to make sure that the federal law against election fraud was being enforced. And therefore, if I am exercising my power to take care of the law be faithfully executed, I'm immune from criminal prosecution. Now, maybe in that instance, the Senate would vote to convict and remove a president, and that person would be removed from office. But beyond that, no criminal prosecution. And that's why there's this sort of fine line between, or really it's easy to conflate. The president's immune from criminal prosecution, but may not be able to get away with what the president wants to do. You have to hope that there would be people who wouldn't go along with the most extreme versions of presidential power. I don't have great hope that future presidents wouldn't find willing aides, but that effectively is the only way to prevent presidents from doing bad things in the future. Anybody else? Okay, well,
Yep, there's a couple of questions in the chat.
well, JP, tell me what they are, because I thought I answered them all.
It was just the last two. Are we really screwed as it sounds, and under which category might it fall? Well, that one you address, the last one.
Are we really as good? I think you know from the tenor of my remarks that the answer is yes, we really are as screwed as it sounds. And there's an additional element here that makes it even worse. The opinion also said that Congress couldn't do anything about this. That Congress can't pass a law that says the president's not immune from criminal prosecution. Presumably, again, if I read the opinion correctly, it's not even possible for Congress to pass specific statutes making presidential activities criminal. Jim Hathaway, is it feasible to expand the court? Well, I'm going to change the word feasible. Is it possible to expand the court? Yes. The Constitution doesn't set a number. It just says there shall be one Supreme Court. And we've had various numbers. We've been at 9 since the 1870s. So yes, it's possible. Is it feasible that it will happen anytime soon? The answer is no. Although I think it's absolutely imperative that it do happen. We should probably have about 15 justices. You could divide them into panels and hear more cases, but also get a broader view, a bunch of broader perspectives. I think that's got to be a long-term project going forward. Supreme Court rulings in favor, what's the likely out that he would enact these newfound executive powers? Anything the voting public can do in a federal and state level? Well, I think, Michael, the answer is really that last phrase, and that is we have to elect people that we can trust. I think we have to elect people at every level of government, president, Congress, all the way down the ticket, that believe sincerely and deeply in the principles of the Constitution, believe in the rule of law, believe in the idea that no person is above the law, to make sure that we don't get bad actors in. I don't know if we get a corrupt president in the future, that there's much that would restrain the corrupt president, because presumably they're going to do a better job finding people to carry out their orders. Okay. Anything else? You're welcome. Well, listen, thank you for coming by. I appreciate it. Maybe I can do this more often, maybe not. But anyway, thanks. I was a little nervous, but I think we did okay. So
Thank you, John.
you're welcome. If there's anything else, if not, good night, everybody.
Hey, you did great. Thank you very much. We appreciate it.
Thank you, David Flipper.
You're welcome.
Thank you, John.
Thanks.
Thanks,
Nice
John.
to see so many
Thanks, John.
people I recognize.
Thanks, John.
Thank you, John.
Good job.
Thank you, Dean.
You're welcome.
Thank you, John.
Good
Thanks,
night, everybody.
Professor. Good night. Thanks, Professor.